the election of 1800. It's very messy. Adams and Jefferson are name-calling. Jefferson wins out. He almost loses to Aaron Burr, his own vice president, but he makes it. Before he can get in, Adams wants to thwart his ability to nominate Supreme Court justices. Right before Jefferson is inaugurated, he has Congress pass an act totally throwing the judiciary into disarray. He adds new seats. He takes one seat off the Supreme Court so that Jefferson can't nominate anyone. And they call this the Midnight Judges Act because at midnight, the night before inauguration, Adams is signing new judges into law. He's just straight nominating all of the Federalist judges he can to thwart Jefferson. This great moment in history is America's first court packing, or unpacking, as it were. Court packing is one of those things where it's like you keep using that word. I don't think it means what you think it means. Court packing means adding seats to the bench to fill them with judges of your choice to change the ideological composition of the judiciary. It's not the same thing as just nominating judges that you like. That's just the normal confirmation process. It's adding seats to change the outcome of the cases before it. The current Supreme Court has 9 justices, but it doesn't have to be that way, and in fact, it wasn't always that way. The Constitution is absolutely silent on the number of justices. Instead, Congress has chosen that number through history, through various judiciary acts. Congress set the first Supreme Court at 6 Supreme Court justices, but it soon changed that with the Judiciary Act of 1801. And that's the very interesting story of Adams and Jefferson. After all of that, Jefferson comes into office and he basically just undoes the whole thing. He passes a new Judiciary Act which restores the bench. It adds back that justice that Adams had tried to take away. And it even changes the date of the Supreme Court term so that it just gets rid of the next term so that none of the judges that Adams had nominated can even take seat. After Jefferson restores the bench to 6, it's fluctuating just based on how many circuit courts there are until we enter Reconstruction, where Congress passed a law, again, reducing the number of Supreme Court justices from 10 to 7 because they were fearful that Johnson was going to undo all of the good that it had done with its Reconstruction measures and all of the rights that it had passed to protect the free blacks. And so they actually court unpack in order to prevent Johnson from nominating anybody who might thwart Congress's Reconstruction efforts. From there, it's again brought back up to 9, where it stays pretty stable until FDR's fireside chats and his court packing plan. Picture yourself in 1937. You're cozied up to the fire and you hear President Roosevelt's voice come on the radio in one of his infamous fireside chats. And from the outset, FDR is beating up the Supreme Court. He says our 3 branches of government are like 3 horses, and 2 of those horses are pulling their weight, and 1 of those horses is not. And that's the judiciary, because they keep striking down all of these laws that I'm passing that are good for the people, that are meant to help us get out of the Depression. He says, just last week, in a 5-4 decision, they almost struck down one of my laws, and that's not right. And you know who agrees with me? The dissenting justices. They also think this is wrong. So what's his plan? His plan is to allow presidents to add a Supreme Court justice anytime a justice turns 70 and chooses not to retire. And his rationale for this is twofold. One point is that it's good for the country. He says, you know, I'm just trying to help the country and the justices are thwarting me, and, you know, I want some justices who are going to uphold my laws. But his other reasoning is economics. He says that we've got a bunch of old justices on the bench and they're really slowing down the wheels of the judiciary. If we had some younger guys, we could move things along quite quickly, it would be more efficient, and you would save money. So he's really appealing to both sides of the aisle here. He's giving one argument for upholding the laws that he likes, and he's giving one argument for saving money, you know, saving some cash by adding some young blood. In fact, I think he actually says young blood, and he says we need some young people on the bench so that we don't only have hardened arteries on the bench. Now, of course, we all know the end of this story. It is the infamous switch in time that saves 9. It is said that Justice Owen Roberts changed his vote last minute in the West Coast Hotel versus Parrish case to side with the liberal justices and to sort of stave off this court packing plan. But actually, in hindsight, we now have the benefit of the papers that have been released from the justices, and we know that actually he was already going to vote that way before FDR announced his plan. And this just goes to show the dangerousness of court packing. Because FDR had introduced it, people see the justices' decisions through that political lens, even when it's not true. And so court packing really politicizes the court and does damage to the rule of law and to the perception of the judiciary. And so I think the story just goes to show how damaging court packing is. The Constitution leaves it entirely to Congress to decide how many federal courts there are, how many judges sit on each court, how many Supreme Court justices there are. And that's because I think they knew that they couldn't anticipate the size of our country, that was going to need to change. The size was going to need to change. There would need to be appellate courts. There would need to be more lower courts. And so the founders trusted Congress to do so in a responsible way. And I think that's right. Congress has the autonomy to do it, and they can change it if need be. But they shouldn't do it solely for ideological reasons. When they're doing it solely to change the outcome of cases that come before the Supreme Court, I think that does long-term damage to the perception of the court as a neutral arbiter of rights. If you enjoyed this video, hit the like button, pack our comments section with comments, or if you want to see more, subscribe and ring the bell.